Welcome to Green's List's breakfast seminar. It's an effort getting up in the morning, but hopefully the three speakers today will make it worthwhile, plus the coffee, etc. Now, we've tried to pitch the breakfast from different perspectives. Mark Gibson will give probably a framework and a bit of sort of fairly essential hints on the record of interview and the process, which some of perhaps the more junior or less experienced in this area will find very useful. Peter Ward will have that perspective of a practical view, the 3 a.m. Call out of the blue, or the call on a late Sunday afternoon when you're just starting to relax. And Sean Cash will deal with a totally different type of client, where he is a professional. He potentially a lot more time to prepare for your interview with the medical practitioners and the like. Now, I'll just give you a little bit of a rundown about each of them before they start. The first one being Mr. Mark Gibson, who's a member of Green's List, who's had numerous years of experience in criminal law. He was Judge Hassett's associate in the 80s. He then went on to practice in every aspect of the criminal law that you could imagine, also with some civil work as well. He spent 2 stints about 10 years ago in the Northern Territory working for Aboriginal Legal Aid, which I can imagine would take anyone out of their comfort zone. He's had experience in the last 10 years or so, predominantly prosecution work in sex trials, murders, other killings, armed robberies, you name it. Mark has worked in that area. On a personal level, I've had some experience with Mark and seen him in court, and he's absolutely unflappable. I learnt this morning that he was an umpire, and so that may explain his total ability to stand there, take the flack from both sides, the judge and your opponent, and still the same facade. He's also a man who's extremely generous with any advice that you may seek from him. He's generous with his time and the effort that he gives in to be of assistance. So I'd like you to welcome Mr. Mark Gibson.
Like a duck or a swan, might be all composed above the surface, but underneath the legs are flapping. You're probably wondering why a member of council who predominantly prosecutes would be contributing to a talk about how to advise clients in terms of their records of interview, given that most of you here would have had more experience at doing that than I have. I think the answer lies in the fact that having prepared lots and lots of prosecution briefs, both at a summary level and more particularly at an indictable level, you sometimes think that maybe things could have been done differently, maybe things could have been done better. And sometimes when a no-comment record of interview has been given, and yet as the trial has unfolded, you can well see a plausible defence, then you wonder perhaps that should have been given at the outset. And similarly, where a record of interview has been given and you wonder during the trial whether that was a good idea, that perhaps a no-comment record of interview should have been given. And I remember one example of an armed robbery that I was prosecuting where during the interview the accused had inadvertently, when asked questions about the getaway car, referred to its colour, had said that in passing it was blue. It was just a slip of the tongue. And the informant seized on this and asked him questions about, well, why did you say it was blue? And the hole started to get deeper that he dug, because he said, oh, look, I vaguely remember, not vaguely, I remember I distinctly remember seeing it on the news, on the Channel 10 news, that the snapshot of the bank and the blue getaway car. And of course we got the footage from Channel 10. It had been taken some 8 months prior to the record of interview. It was a 7-second grab, and there was no way in the world he could have learnt the colour of the car from the Channel 10 news. So it's with that background that I thought perhaps I can contribute to this talk, because the advice that you give your clients at that early stage of the record of interview can more effectively shape and mould the way in which you conduct the trial. And that's really what this is about. I know that we, or the defence solicitors, spend a lot of time on the interlocutory process, the pre-trial process, issuing subpoenae and the like, in order to set the trial up. And I know that defence counsel spend a lot of time and energy with the trial itself. But if more time and energy and a little bit more thought can be put into the advice given to clients at that record of interview stage, then the shape of the trial is better formed. It's important to remember that Section 464C of the Crimes Act, the mandatory provision that allows an accused person who's about to be interviewed, if he's in custody, he has the right to communicate with a legal practitioner. And communicate just doesn't mean have a word to him or shooting from the hip from the point of view of the practitioner. It means giving effective, sound advice to the client. And so, as Joe just said, what I propose to do is just simply give an outline of or a basic philosophy that you should have in mind. It's really directed to the less experienced practitioners, the younger practitioners, so that when they, perhaps for the first, second, third time, get that opportunity of giving advice, they have these points in mind. And so the basic roadmap or framework that I would suggest that young practitioners, less experienced practitioners should follow is, firstly, to be alive to the consequences of your client speaking, that is making a commented record of interview, or not speaking, making a no comment record of interview. Obviously, if the advice is not to comment, then, not in all cases, but the majority of cases, it will result in your client having to give evidence. And if you're giving evidence, you'll be cross-examined. So it's important to bear that in mind. It's a very big decision to advise your client to make a no comment record of interview, because it does mean that he'll have to perform to a certain standard in the witness box. And of course, if at the end of the day you haven't given a record of interview and you don't give evidence at the trial, then it's going to be more difficult to argue that a reasonable hypothesis consistent with innocence exists. It's going to be easier for the prosecutor to argue that all reasonable hypotheses consistent with innocence have been excluded. And really, at the end of the day, that's the main point of a trial. The main point from an accused point of view is to raise that reasonable hypothesis. The Crown is always trying to exclude it. So the first obvious point is that if you're going to advise your client to make no comment, then either he or she has to give evidence, or you'll be left in that position of where it's more difficult really to exclude that innocent hypothesis. Now, there are some cases where that's not necessary, and it just depends on the facts of the case. Sometimes if, say, for example, voluntariness or consciousness is an issue, then it may not be the situation where you either have to give a record of interview or have to give evidence. And recently I was in a case where that very situation arose, where she hadn't given a record of interview, she didn't give evidence, and yet she was acquitted because the Crown ultimately weren't able to prove that the act was done voluntarily or consciously. Now, When making the decision to comment in a record of interview, then that can have benefits, and it can also be unprofitable, as we all know, because effectively you are nailing your colours to the mast. You're committing to a version, and that can be profitable if things work your way, and at the trial that position that you maintained at the very outset really hasn't been shifted at all, then that's a profitable position to be in. But on the other hand, by committing to a version early, if it transpires that subsequently there is evidence that overwhelmingly proves the opposite to what you've said in the record of interview, for example, DNA evidence shows semen, or there's CCTV footage showing you at the scene, or there's a fingerprint, your fingerprint on the windowsill of a premise that you've allegedly broken into, then, or there's an independent eyewitness, which is sometimes the case, then you're in trouble because your version has been proved wrong. And that means that if it's shown that you've lied, then the prosecution can allege that lie either as a credit issue, that is, that the credit of the accused person has been adversely affected, or, as we know, consciousness of guilt, or as it's now called, post-offence incriminating conduct. So you've got to be wary of the fact that if you do go down that path of recommending a commented record of interview and effectively committing to a version nice and early, then just be wary of the possibilities of things not turning out your way in the end, and you having to then attempt to rectify it at the trial, either by giving evidence and offering an explanation as to why you maintained position A in the record of interview but are now maintaining position B, or if you don't give evidence, then the task for the defence counsel is all the more difficult. It's also important to bear in mind when you're considering the advice that you give your client to consider his appearance, his demeanour, the condition in which he presents, and if it's a serious offence, it'll be on video, and of course the jury will get to see if he's in a dishevelled condition or whatever other condition, then they'll see that. If it's an audio, then the jury will get to hear the demeanour of the accused, the intonation of the accused, the pauses that he might utter in between questions, particularly questions on that go to the heart of the issue. So they'll get to hear those things, and all those types of things go into the melting pot when you have to make the very important judgment call on whether or not to make a commented interview. In the Queen and Barrett, Justice Eames spoke about this assessment by jurors of the credibility and reliability of all witnesses, including accused persons, based on their appearance and demeanour. And in that case, 2007, 16 VR 240, and I note that Sean refers to it in another context, the selective answering context, in his paper, which I commend to you. Justice Eames said, it may be that in some circumstances the conduct of an accused person, as captured on videotape, would support a conclusion by jurors that it demonstrated consciousness of guilt. However, occasions when guilt could be proved by demeanour displayed during a record of interview would be rare indeed, having regard to the unreliability of demeanour as proof of the state of mind of any person, let alone as proof of guilt of a criminal offence. The dangers of misinterpretation of such conduct are well recognised. That is not to say that the assessment by jurors of the credibility of witnesses is not influenced by the appearance and demeanour of witnesses. Inevitably, it must be that jurors are given a general warning about their observations of witnesses, to make allowances for stress and other factors which might bear upon their composure, it is quite a different matter to suggest that the guilt of the accused could be proved by demeanour alone, which is the conclusion that the jury were invited to reach by means of consciousness of guilt reasoning in this particular case. So all I'm saying is that one of the obvious considerations when you speak to your client, and more importantly see your client, is the way in which he presents. And if you think that down the track, when the jury are watching this video or listening to the audio, that it may reflect badly on his credibility, then that's one of the important considerations in perhaps advising him or her against answering questions in the interview. Sean is going to speak about selective answering, but could I just say at this stage that, and when I say selective answering, I'm talking about a number of responsive answers to questions, but punctuated by no comment answers to a few questions. And I would caution, or I would urge you to caution your clients against selective answering. It might be that the other speakers have a different view of this, but I don't think it's a good idea, not because an adverse inference can be drawn from no comment answers, not because a consciousness of guilt argument can be raised by no comment answers. We know that that can't happen. No comment answers means that you can't draw adverse inferences from it, means that no consciousness of guilt argument can be run. But selective answers may lead to other responsive answers being used or treated as false denials. So what I'm saying is that whilst the temptation for accused persons may be to answer the questions that he or she doesn't mind and no comment the ones that are a bit tough, there are some situations where because of the other responses that he or she has given, those no comment answers can get into evidence. And the Queen and Barrett is one such example, that case that I mentioned before, where no comment answers were admitted into evidence by the trial judge, and the Court of Appeal said that there was no miscarriage of justice as a result of that. Now, it only happens in peculiar circumstances, and in this case, that is Barrett, the reason they got in was that the other relevant and probative answers that he gave were not comprehensible without being read with the no comment answers. So there are a whole lot of other questions and answers. Unless the no comment answers got in, then the other ones weren't comprehensible, and that's the reason they got in. But it's a bit of a bad look if, as in this case, where there were certain items found, it was a murder case, items found at the premises. I think they were a knife and some wood. He was asked about those, that is at his home. He said no comment. He was asked about whether the knife and the piece of wood belonged to him. He said no comment. He was asked about some blood-stained paper and sponge that had been found in his rubbish bin outside his premises. He said no comment. He was asked about bleach. He said no comment. Bleach obviously used to wipe down the walls of blood, etc. And he was also asked about some documents that showed that these items had been purchased at Coles recently, to which he said no comment. And they were allowed in because, as I said before, the other relevant and probative answers weren't comprehensible without those. So it's just a word of warning. It's just something that you should bear in mind. The main thing to do when you're about to speak to your client is to gather as much information as you can. And that means speaking to the informant, making sure you speak to the informant or the police officer who's about to interview your client, and find out as much information about why your client has been arrested and anything else you can learn about the alleged offence about which he's to be interviewed. If it's an aggravated burglary, probe the informant as to whether or not there was any sign of a break-in, what the means of entry were, whether if it's an assault case, probe the informant about the nature of the injuries on the victim, whether she's got, for example, if it's a sexual assault, scrape marks down her back, which might mean that your client has her DNA under his fingernails, and things of that type. If it's a assault with a weapon, ask where the weapon was found. I had a case once where that occurred, where my client had been charged with a serious offence, and the first thing I did was to speak to the informant, and he quite graciously, although I'm sure there was a reason behind why he was telling me this, but he did tell me where that a weapon had been found, where it had been found, and its condition, i.e. with blood on it. And where it had been found indicated to me that I needed to be careful, because where it had been found was inconsistent with a burglar or a trespasser secreting it where it had been secreted, and was more consistent with perhaps my client having been responsible for where it was secreted. And so it just sort of put me on guard, and they're the sorts of things that I'd recommend to you when you, just before you speak with your client. Consider obviously the nature of the offence. A complicated fraud or a complicated or a prolonged theft from an employer may have different considerations simply because of the nature of the offence and the amount of perhaps documentation and the time frame over which the alleged offending might have occurred from, say, a single event such as an assault. Listen to what your client has to say. Take some time to just simply hear his version, because all the while you're making a judgment on whether or not it's plausible, because that's at the root of this. Probe him, quiz him, cross-examine him if you can, just to get as much information out of your client as you possibly can. Be prepared to give advice to your client as to the law. It might be that your client says to you, look, yeah, I was there, but I wasn't the one who kicked him, or I wasn't the one who punched him. It was my mate. So you need to be aware of the law of complicity, concepts of joint criminal enterprise, common purpose, extended common purpose. All those things need to be in your mind so that whatever the offence is, you can give him proper legal advice. Lastly, you need to bite the bullet. When your client says to you, look, what advice should I give? What should I do? Should I speak or not speak? You need to be prepared to bite the bullet. And I think at the end of the day, you need to ask yourselves, is what I'm being told plausible? If it's half plausible, then my advice is to go with it and to answer questions, taking into account the things I said before about presentation and demeanour and the like. But if you can get a half plausible defence up and running early in the record of interview, it will obviously obviate the need to give evidence down the track and be cross-examined by the prosecutor. You people have more experience of this than me, but generally speaking, at trial, accused persons don't fare all that well. So that's why I say the bottom line really is it plausible? If it is, then comment. If, on the other hand, there are just too many unknowns, too many variables, just too many things that you're just not sure of, whether it be the CCTV footage that you're unsure of because the offence is said to have occurred in a public place, the DNA on a cigarette butt or whatever, if there are too many unknowns, then that's perhaps the time to recommend no comment, because you just don't know what you're getting your client into. And it might be better to get the police brief, have a look at it all, and then construct a case concept based on what you know is in the police brief. Sean's going to speak in greater detail about setting up a plea, but it might be that if you come to the conclusion that your client is guilty, or at least his chances of an acquittal are remote, then your tact should change, provided that you've got the consent of your client. And the record of interview is a perfect opportunity to set up a plea. And I really think it's not done often enough. And it's a bit tough because you have to make the decision, okay, I'm going to make admissions. But if you've come to that conclusion that I'm not going to be contesting this, then we'll get in there and express as much remorse as you can. So just in conclusion, as I said at the outset, I don't think I did say this, but there's no right or wrong way of approaching this. It's all about judgment. It's all about giving your client informed advice so that he can make an informed decision. And if you're worried about advising clients in the wrong way and messing up, then there's this expression, this saying, good judgment comes from experience. Experience, well, that comes from poor judgment. So good luck.
Thanks, Mark. The next speaker is Peter Ward, who I think next year clocks up his 40th birthday in the legal practitioner, as a legal practitioner. He completed articles under Frank Galbally in 1974 and then has really practised exclusively as a criminal lawyer since then. Not only is an accredited criminal law specialist, he's highly regarded. He represents his clients through all the jurisdictions, everything from the Children's Court to the High Court. And if you haven't seen him in the courts, waiting in a queue see a police prosecutor, or being interviewed on the steps outside court, ladies and gentlemen, where have you been? Because he's Mr. Everywhere Man. I'll let Peter talk about the 2 a.m. call. We may have a break halfway through, and I apologise to Peter for coffee or whatever. We'll see how we're going. Thank you.
Thank you very much. What I'd like to concentrate is on the instantaneous advice. Sean, obviously the best thing to do, if you can arrange, often clients will ring and say, look, the police want to see me Thursday at 9 o'clock. Well, for heaven's sake, get them into your office, go through it and give considered, conscious advice. What I'm confining my talk today on is the instant call at night, at dinner time, in the morning. And you can be doing some very interesting things when these calls come through, I can assure you. But it's a question of getting the call and making a judgment. And as Mark properly said, in my view, each case is different. Each practitioner sometimes has a different view, but at the end of the day, you've got to call in your experience and your judgment to make a determination. So I'll concentrate on the phone call at night or the phone call on a weekend. So you get the phone call from an informant who's often more awake and more sober than you, and he'll indicate to you that Joe Bloggs is being questioned. As indicated by Mark, it's very important to milk information from the informant. So don't just immediately, in my view, speak to your clients. Speak to the informant and get as much information and history about your client. Now, what I've found, and I find it quite interesting, informants are very enthusiastic usually, and there are exceptions, about talking to you because they want to tell you how thorough their investigation has been, how much evidence they've got, how your client's really got no option but to plead guilty. But in their enthusiasm, and perhaps you could call it skiting, they'll often give you a very good history so that when you come to talk to your client on the phone, you've already got a good précis background. Obviously, you've got to factor in that it's a bit biased and you have to take away the enthusiasm of the informant. But when you speak to your client, you should have as much information as possible. And in a practical sense, it is quite difficult, often given the hour and given the circumstances that you're in. Now, when you come to speak to your client, and you can only talk in general terms, most clients, in my experience, are really not that interested in what to say or what not to say. They want to get out of there. Mate, I've got my family. I want to pick up my son in a half hour. I want to get out. Get me bail. Whatever you do, get me out. Now, that's a very dangerous concept, because although it's inappropriate, many informants, and some are silly enough to tell their clients this, but many informants induce people to speak on the basis that they'll give them bail. And too many clients take the bail carrot as distinct from taking the advice about their future in terms of the charges. And I can remember one case where the informant, I will say, enthusiastically encouraged the accused to speak. He got bail, terrific, but 6 years later when he was released, that's the point you have to take into account. The keenness for instantaneous release can often override a client's common sense. So I think it's rather important when you're speaking to your client is to assure them that you will do everything you can, if possible of course, to secure bail, and you'll put all your resources into helping them. But I think you really need to get them to focus on the issue at hand, and that is the record of interview. First thing I say to a client, because a relationship forms between the client and the investigator, is for heaven's sake to be polite. And now you might think, well, why is it important to be polite apart from common courtesy? Because the informant's view and attitude to the client is paramount. A, with the issue of bail perhaps. B, assisting the accused by way of cooperation and manners, diversion, which I'll talk about later, if appropriate. But so many clients are aggressive and say, oh, the bloody coppers, they railroaded me. And if a client starts off in an aggressive, threatening way to the police officer, he'll never get anywhere. Now, I'm not saying that politeness means cooperation and making admissions or that sort of thing, but get your client, in my view, to just be civil and courteous and polite, because I think the relationship with the informant can be, not in all cases, a very important situation. Don't be afraid as to how long you talk to your client when you're on the phone. They're facing often very serious, significant criminal charges, so don't be in a rush. And the second principle that I would put forward is try to relax your client, try to assure him that you're looking after he or her, and try and get them in a relaxed frame of mind so that they can concentrate on the job at hand. Apart from settling them down, apart from telling them to be polite and to just relax and to deal with a critical situation, you're at the back of your mind focusing on what advice to give. Now, I would say, data-wise, most people are told with the instant advice, and I'm contrasting that to the advice that Sean will talk about when they're in your chambers or in your office and you've got an hour and a half to go through it. I suppose the numbers would stack up in telling your client to make a no-comment interview given the instantness of the situation and all the issues. However, if you determine that your client is articulate and you satisfy yourself that he does have a defence. I agree with Mark that you've got to be careful, and there are some exceptions to the rule. I think it's intelligent and sensible to get them to articulate their defence. Obviously, time constraints, the hour of the day, often the situation at hand makes that difficult. But if you're confident that they can articulate a matter, for heaven's sake, get them to talk. Now, the central issue, I guess, when you're giving advice, you've really got to, I frame it this way, if possible, and it's not always possible. The question I ask myself is that, can the prosecution prove their case if the accused does not make admissions? In other words, if he shuts up, can the prosecutors prove their case? If the answer is no, in other words, and the police need the missing link with admissions or information, well, clearly the advice is to make no comment. I understand and appreciate that that question cannot, in all instances, be answered. But when it can be answered, when you can be confident that they haven't got a case without admissions, the clear advice is no comment. But as I say, there are calls to make, and it's a very difficult judgment to make. I just want to, Sean deals with this in his paper in a different way, but Mark alluded to people having a view. I firmly believe that selective answering in a record interview is rubbish. You have people giving answers to questions where they were, and immediately the crunch comes, they say no comment. Well, to me, in my humble experience, that is damaging, and I've never been an advocate of selective answering. Sean, and we don't want to steal Sean's thunder, but Sean alludes in his paper to a situation where a person may go in and say, I acted in self-defence, and then no comment all the way through, may open up or may provide a statement. That's a different matter. But how many times do you see interviews where they've answered every question and the crunch comes, they say no comment? Well, to me, that is a damaging document, and although people may disagree, of course, I'm very fixed in that point of view. A couple of points I want to make. If your client is under the weather and very drunk, and often you can tell, they're more inebriated than you are, you can tell. If they're drunk, don't be afraid, or if they're affected by drugs, or or you can ascertain that there's something clearly wrong with them, say to the police officer, look, and you've got their name and their details, that's the first thing you require. Say to the officer, look, I don't think you should conduct this interview. He's affected. I've made, and again, very politely, not in an aggressive way, but say to the officer, look, I take the view that he's not fit to be interviewed, and I just want to say to you, we'll be taking issue with that, and you should delay the interview until he's medically examined. Now, don't expect the informant to necessarily jump at your request, but you've noted it, you file note it when you get to the office, and you are then able to raise it in the course of future criminal proceedings. Interpreters. If you can't understand your client because he or she is having difficulty, and if you can't conduct a rational conversation due to a language difficulty, for heaven's sake, say to the informant that you're not happy. You're not. You think that an interpreter needs to be obtained. You think that the matter should be held over until an interpreter can be gained. Again, they will. That doesn't necessarily mean to say they'll adhere to what you're saying. But again, if you note it and you raise it at the time, it's a very sensible thing to do. I guess my whole view, and I think when you're giving instant advice, you have to be more conservative. If in doubt, advise your client to make no comment. But what I urge today is that it's unlike the old days when 20 years ago, it might be longer, Mark will know, when they had unsworn statements. It was a general tendency to advise everyone not to say anything because you could correct things through unsworn statements. Those days are gone. As Mark has very properly and sensibly alluded to, in a lot of trials in particular, the client who makes a no-comment interview is often, not always, often required to give evidence. So they're factors that you have to take into account in giving your advice. I suppose the purpose of this morning is to get everyone to think about it. Too many people just say, oh, no comment, without thinking, without alluding to the important issues that Mark raised. So I think you really have to exercise your judgment. And there's no doubt when I've got to the office on some occasions, I've reflected and I've been worried about my advice and discussed it with colleagues. So regardless of how many speakers there are today, we probably won't see eye to eye on everything, but I think we would all passionately agree that it is an important exercise and it's an important issue that you have to take. Well, I'll now go into a few examples for your consideration, and I don't mind if anyone wants to shoot a question or raise anything with me in the course of this. Now, I want to talk about diversion and the advice. Now, as you all are aware, diversion, one of the faults of diversion, it has to be approved by the informant, which in reality is a ridiculous concept because the informant is not required to give a reason as to why they oppose diversion. I've seen cases where I'm staggered that diversion has been recommended. Conversely, I've seen cases where it's pig-headedness and just a lack of bother. So, but I'm not here to comment on whether police should or should not be required to recommend diversion. But diversion is an important consideration in your advice. And I'll just deal a couple of fact situations. For example, if a chap is caught with 10 grams of marijuana, or a small quantity of marijuana, or another substance, and it's quite clear that the drug is their personal use, nothing wrong whatsoever in making a full-born confession. If the drug is of a more addictive nature, you often should use the interview to advance what you're doing. Look, I've got heroin, but I'm starting treatment, or I've seen a counsellor, I want to continue my counselling. All that will go in your summary and will go in your record or interview, and whether diversion is granted or not. Those issues, you can work your interview to your favour. You can work your relationship, this is an accused person, with the informant to their favour and set up, and as Mark alluded to, you can set up the plea. So with minor matters, there's a greater emphasis of cooperation, a greater reason to speak to the police, because if you, and there are plenty of cases where you do get diversion if you maintain your rights not to make admissions in your interview, but clearly it does assist in the diversion process if you cooperate. I'm not suggesting for one moment that you make admissions if they haven't got any evidence, but I'm thinking of the shoplifter who's walking out with the plasma. Well, why on earth wouldn't you confess and say, look, I took the plasma, so long as it's true, of course, I'm dealing with truth, but, you know, my wife and kids, you know, the kid hasn't seen Bugs Bunny for a few weeks, so that's why I took the plasma. But, you know, why not make admissions? If you practice in the criminal law, in my view, you've got to have the courage and the audacity, as it were, to make a call. It is very weak, in my view, to just say no comment, no comment, no comment to everything without thinking. I think it's weak, and I think it's an abrogation of your responsibilities. So diversion is a significant factor, and it's an arm. It should be magistrate driven rather than police driven, but nonetheless, and it comes back to my earlier point, it doesn't cost you anything with an informant being a practitioner or an accused to be polite and respectful. Now, I'd like to turn our attention to and Mark alluded to this, what we're going to do today, we're all going to steal each other's ground, but that's what we have to do. Assaults in public places, 7-Elevens, public venues, gaming houses, railway stations, etc., where CCTV footage is paramount. I'm reluctant, despite the possibility of an articulate defence, for people to make admissions in that situation. I recently had an experience where obviously I saw my client sober in the office, but he said, look mate, they were coming at me. I gave him one punch. I know he hit the ground, but there were 3 or 4 guys that were coming at me. I was defending myself. And I thought, gee, that sounds okay. And he'd made an interview along those lines. When we turned on the CCTV footage, I thought it was Muhammad Ali. He was punching people left, right and centre. The picture tells the story. And versions can be tested, versions can be contested, and they can have different interpretations, but the CCTV footage often tells all. And there's nothing worse than just a false denial and a false story that can be shot down in flames. So I have to be persuaded very cogently to advise clients to make admissions when you know by your experience, and you can even ask the informant, but you can guess as if it's at Southern Cross Railway Station. I'm always very reluctant to advise clients to talk in that situation. Another issue, which is a side issue, but when talking to your client, make sure that you tell them not to talk to anyone about their instance. Sometimes you've achieved your result. They either haven't said anything or they've given an articulate version based on their instructions, and then you get the brief and then there's a pretext discussion. Rape case. police have complainant in tow at the police station. The complainant who's been in a relationship with the chap for many years and he's raped her or done something heinous to her, she rings up and says, "Fred, why did you do this?" And he says, "Oh, I'm really sorry, I was drunk, I was frustrated." Then you're in real trouble. So always advise your client not at the police station, not to discuss the matter, and not that they should be speaking to complainants, but not to discuss the matter, because how many times does Mark pull out the pretext conversation and we go down? Now, I want to talk about rape cases. I've had experience where people, this is perhaps not totally on point, but it's on the borderline, where people say to you on the phone, "Look, mate, I wasn't there, she's dreaming, it was another bloke," etc., etc. And they try to convince you, and so they give an interview saying, "Look, I wasn't there, I was at the beach, it was my twin brother," etc. And then you get the brief and DNA plants him right and truly at the scene. There's one infamous policeman whose name I'm not allowed to mention, but he was astute enough. He had the evidence and encouraged the fellow to persist with his story. And when the brief comes, his defence magically changed from "I wasn't there" to she consented and enjoyed it. So you can see that false denials, the point I'm trying to make is false denials and matters that are complete rubbish. There's nothing worse than a false denial, and there's nothing worse about changing defences midstream. In summary, it's a difficult area, and you have to make a judgment call, but be aware of CCTV footage, be aware of DNA, and just make an assessment on the articulateness of the client. If the client is really agitated or disturbed in any way, for heaven's sake, no comment. And I come back to my general premise of no comment. Because I'm a bit shorter and probably not as well prepared as Mark, I'd be happy to answer any questions in the short time that I've got available.
We might do it at the end.
Yeah, we might do that at the end. Okay, thank you very much.